Thanks very much, everybody, for coming today. My name's John Ahern. I'm the CEO of InfoTrack. The reason we're here today is to talk about AML and CTF and Tranche 2. So the Australian AML CTF Act was introduced in 2006 to combat money laundering and terrorism financing, but it's been widely criticised, especially over the last few years, and most recently in the wake of a few high-profile news articles involving Tabcorp being fined for breaches and CommBank being investigated for alleged breaches. So far, only Tranche 1 is in place, and that regulates financial entities, but there's an increasing amount of pressure to implement Tranche 2 to extend the obligations to gatekeeper professions, including lawyers, conveyancers, real estate agents, and accountants. It's widely believed that Tranche 2 will come into effect this year. And we want to explore how this is going to impact our industry and what specifically we can do to prepare so we're not caught out. I recently led a roundtable in this office with experts you see here today on our panel who are sitting here in the heat, which I can tell you is worse at the front of the room, to discuss the topic, and a few key concerns came out. Mainly, the industries are underprepared for Tranche 2. There's limited knowledge of what it will mean for us and how we can prepare for it. There's a need for education so that we can understand what AML CTF compliance is and what we will be required to do. So first of all, welcome to our panellists and thanks for being here. All right, Geoff, first question for you. Why are the gatekeeper professions being targeted in Tranche 2 and what can we learn from New Zealand's rollout?
The term gatekeeper really refers to solicitors, accountants, conveyancers. It comes from the notion that these professionals can provide a gateway to the financial services and property sectors. And if they're not managed and if they haven't got compliance obligations around knowing their clients and anti-money laundering and counter-terrorism financing, they can be targeted by their clients to set up sometimes quite complex structures to try and increase the space between the identity of a criminal and their assets. So, for example, if you're a solicitor or you're an accountant and your favourite client, Derek the drug dealer, turns up reporting his inheritance from a distant relative in Colombia and he wants to start setting up company structures in order to buy assets. Currently, there's no real obligation on the solicitor or the accountant to report that to AUSTRAC, our financial intelligence unit. So the government is proposing that these professionals who provide designated services, so if you're, for example, a solicitor who simply does defence work, criminal defence work, that work should not bring any obligations. But if you assist your clients to structure artificial entities like companies or trusts, or if you manage their finances for them, then it is likely that those are the types of services that will be captured. So when the legislation comes out, we wouldn't expect to see a blanket term for all solicitors. It will be designated services provided as part of your business. The notion also is that it helps spread the burden of compliance across different entities, so it doesn't just rest with financial institutions and the gaming sector and bullion dealers, for example. What can we learn from New Zealand? Speed is of the essence. With New Zealand, entities that are captured by their legislation have between 6 and 10 months to comply. And so, for example, solicitors in New Zealand have to comply by 1 July. So it's not a lot of time to do a lot of work because it requires risk assessments, it requires putting programs in place, training, understanding how to know your customer, how to put in processes to report suspicious matters and threshold transactions. So they didn't give organisations much time to comply in what is a fairly complex area, and that requires quite a significant investment in technology to be able to do it efficiently and not impact on your customers.
Thanks very much, Geoff. Gavin, can you talk about what are the minimum requirements here and what are the risks of failing to comply with these?
Thanks, John. The minimum requirements, I've just been talking to Orb Chapman, and many of you may know, the rules are just being finalised now for the next Tranche 2 to come through this year, as expected. Now, it's going to be hard to look at it and say, is Gavin going to be right or wrong on this? Frankly, I'm always right. But the issues around this is going to be things like know your customer, customer due diligence, reporting. Now, this is going to be an issue, and I'm not sure Clayton, you have a point on this, where it comes to client legal privilege, because for lawyers it's going to be hard. It's under designated services, and I do understand that. If you are offering a designated service, which is a trust, company structures, conveyancing, you may choose as a lawyer or real estate to de-risk, meaning I don't like this customer, I don't know where their source of income is, but they will expect you to do that. Ultimate beneficial ownership came in about 2 years ago. Ultimate beneficial ownership means anyone owning over 25%, you have to make reasonable efforts to understand who's the benefit, who's going to be beneficiary of that trust or company. Now, my understanding is that reasonable efforts for one of the banks meant 17 trusts. If you're a lawyer and you set up or are asked to set up a company structure that has 17 tucked away trusts, would you find that suspicious? If you find it suspicious, you will have an obligation to report that. Now, where the client legal privilege will step in, I'm not entirely sure. I don't want to talk about that until I pass it over to Alexia. But you'll have a reporting obligation, which means cash transactions, suspicious matters. Now, the tricky one will be risk-based approach. You will have to have a risk-based approach within your business, which means you'll have to look at all the transactions and your clients and do the due diligence to understand where the vulnerabilities within your organization sit from a risk to or vulnerability to money laundering and terrorism financing. Now, many, many years ago on the first round of Tranche 1, I was at a similar event where the vice president for Citigroup stood in front of an audience of about 150, 200 people, and he announced himself as the vice president for Citigroup and said, "I'm the Citigroup vice president, the money laundering bank of choice." And everybody in the audience went, "What? Who? How can you say that in a public forum?" And he said, "Well, we are the largest bank, and therefore it'd be silly of me not to assume that we have the largest amount of money laundering happening in the largest bank." So my comment around that is that if you are in conveyancing, you are a lawyer, and Tranche 2 that captures you has been delayed now for some time. It was promised back in 07, 08, so we're going 10 years. That you are probably already vulnerable in a certain way to some money laundering happening within your organization. You will have to go back and look at all your clients, do your due diligence, and the term du jour at the moment is de-risk. The banks are doing it. I would imagine your organizations will have to do it. You'll have to look at your clients and say, do we, from a commercial perspective, want these clients within our organization? So from an obligation perspective, I'd imagine that's what InfoTrack will expect you to do. I really do. I think they're going to ask you to make sure you have a risk-based approach. My experience from the first round was when Tranche 1 came in and everyone looked at the risk of their clients, they just went, well, they're all low risk. Are they really? All the high net worth individuals? The company structures, they're all low risk? So don't fall into that trap, and I'll talk about that, I think, later on. I have a question. So your obligations are going to be customer due diligence, know your customer, a risk-based approach, and reporting. Failure to do so, as is thanks to CBA, failure to do so, I would put probably, from your perspective, reputational damage. It's can your business sustain a front page article that says you are now laundering someone's money, or, God forbid, funding terrorism? And the terrorism finance is a very, very difficult topic, because now with clear skin and homegrown terrorism, it's done for very, very little money. In the old days, it was very easy to do. You all said money laundering was dirty money to clean. Terrorism financing was clean money through a charity used for a dirty cause. That's all gone now. And no one really knows how it works. And I'll be the first to admit, I think all organizations struggle with the idea of where the funds come from for terrorism, especially if it's homegrown. But reputational damage would be the first thing I would say from your business is make sure you do this. Secondly, with CBA, it's the fines. The new CEO, Nikki Rose, she's just come on board. Nikki Rose made it very clear she's going to step up the enforcement action of AUSTRAC. Now, there's 110,000 new entities coming on board with Tranche 2. That's the estimate. 110,000. Many of you might just be sitting there going, well, do you know what? I don't think we'll ever see AUSTRAC. I don't think they'll ever turn up. So, frankly, we're going to do nothing. So, yes, that could be one perspective. But can your organization bear, if you are suddenly picked out for an audit, if you've done nothing, AUSTRAC will, our old CEO said this, if you've got one bullet to fire, make sure it's a live round. Because that's what AUSTRAC will do. They will choose somebody, find somebody, and make an example. So do you want to be one of those people? So I truly believe that AUSTRAC is going to upstep or enhance their enforcement action, and they've built a whole raft of new IT background stuff that means you've got an obligation to register with AUSTRAC. You must register with them. And if they see no reports, and they never hear from you again other than just register, your name will pop up, and they'll say, well, let's do an audit. Let's go and see what they've done. So that would be my consideration on that.
Thanks, Gavin. Alexia, Gavin briefly mentioned there that there is a bit of a conflict here, a conflict of interest between professionals playing their role as that trusted advisor while having also to essentially police their clients at the same time.
Yeah, thanks, John. I think this is where this becomes a concern for lawyers. So, first of all, I think every lawyer in the room would say that they denounce money laundering, criminality, and terrorism. I think that goes without saying. However, then you think about the traditional role of lawyers as the trusted advisor, the provider of independent legal advice, the fundamental things that we talk about around confidentiality and legal professional privilege. And with Tranche 2, in the event that it is extended to lawyers, the situation that you may have is where, particularly with suspicious matter reporting, you have a client come in the door, you become suspicious of something they're doing, you immediately would have to cease to act without telling them any information about why, because that would be tipping off an offence. And so you can see that sort of clashes with that traditional role of what we consider with lawyers. So how do you as a lawyer then maintain that independence, maintain that duty of confidentiality to your client, encourage your clients to still share openly, because you need clients to be telling you everything about what they're doing, with the knowledge that then that independence and trusted advisor starts to fall away, because you may actually be caught up with the suspicious matter reporting regime. The other part of that is that you want to see that if this regime is imposed with the compliance burden that comes onto lawyers, that in fact you are improving the actual outcomes. Are you reducing money laundering, or are you reducing terrorism financing? A concern for us is we wonder whether there's objective evidence of whether these regimes actually work. So there's lots of stories, there's lots of sort of different suggestions made, but it's very rare to see it actually in action.
Thanks, Alexia. Ronald, your job is implementation. You're the project manager. What are the main challenges for businesses in implementing a compliance program? And where will there likely be gaps?
So, implementation in the regulatory space is difficult. If you've got an existing regulatory regime in place within your business, you don't really know what you have to change until you actually get into the detail. And then you find weird and wonderful things where process hasn't been implemented correctly, or you find gaps, worse still. And those things are true for an existing regime, an existing regulatory. Now what we're talking about here is brand new compliance. Now, if you're implementing AML CTF for the first time in law, you've got brand new compliance with a brand new industry. Now that makes things a little bit more interesting. All the paperwork and advice and so forth you see is generally focused around financial services and how you operate within that. Now, If you're operating a legal business, within that, how many of your services actually result in some sort of money trail activity and therefore AML CTF? That's an interesting point. And, does that represent part of your business, a lot of your business? All of those sort of questions come to be. So brand new compliance, limited advice for applying this heavily orientated finance regulation to law. That's the first thing that needs to be worked out. And how do you do that? And as you get into it, the next part is you really got to start with convincing your leadership. The AML CTF regime, when it goes... The AML CTF regime, that's better, isn't it? Sorry if you didn't hear back there. The AML CTF changes when they come towards our industry is, you've got to convince your leadership. The essence here is that, this has to be driven top down. There are obligations to senior management, and you nominate effectively an AML CTF officer within your firm who is the liaison to AUSTRAC. And, they're on the hook for a number of things, including criminal charges as well. So, this is really has to be driven top down. And the big impact there, and I'll talk about this in a second, is, you've got to convince our lawyers as to, how do you spot these things and what are the things you need to report. That's not something you can just drive out the back of some small project coming in. Here's a regulatory tweak that we're going to put in. It's brand new. It's got to be ingrained. And the whole, this is true for any sort of regulatory change, is you've got to drive it via culture and therefore has to come in top down. The other parts are, if you're coming along with a brand new regulatory action or new compliance coming in, how do you sell that to all the people who are taking that, your lawyers and so forth? You need to look for an angle, and then that is, is there a business process opportunity? Gavin just mentioned just before with regards to KYC, which is Know Your Client. And Know Your Client is heavily focused around that client onboarding space. Brand new clients are coming in, trying to identify who they are, what they're about, what they're doing. And that in the legal terminology, that's client intake. You'll have to look at how you're going to change client intake. And if you're changing client intake, are there opportunities of, capturing other information around your client at the same time? Can you put in, what's popular coming out of the UK at the moment is, in that client intake process, they're looking at where they can look at finance opportunities, looking at how much credit risk a client might have and those sort of activities. So those are the things you might want to consider if you're going to change and put in KYC processes in your client intake. What else can you change and how can you better sell that within your business?
So Ronald, you can't just say to your client, I'm just going to charge you more now because I need to spend a bit more time getting to know you. You can't do that. Rather than do that, look at it a different way.
I think your question is fundamentally, who's picking up this additional cost, right? That's so if you spend, if you're spending half a day doing client due diligence in a really complicated business entity with the 17, 18 trusts and, 3 directors that are based out of the Isle of Man, who's picking up that time? And, the way we see this at the moment is interpretation is everything. In a sophisticated AML regulatory environment, clients will be aware of that. They may even turn up with packs to say, hello, here I am. Here's my AML CTF pack, and this is how we can talk. So for us at the moment, looking at how we can do this, that's potentially, loss of billable time. If your partners or lawyers or fee earners are actually on that front foot, performing that diligence up front. So that's a challenge, and that needs to be worked out as well. I suppose the last bit with regards to that is you really got to understand what your client base is made up of. The anecdote comments are, half my base is PTY Limiteds and so forth. Is it? Is it PTY Limiteds? Do you actually have enough information on there to make that, that judgment? Is it made up of listed companies or those sort of things? So the reason why that's important is that then your due diligence, some of it could be automated, so there are third parties that could provide that information. How much of it can you actually do? And so how much of it do you actually need to go back to the client with? And that's a real challenge. How much do you go back to the client with? And, in the early days, will they take offense? So, those are the sort of challenges we're sort of seeing. And those are the gaps, fundamentally I'd say in summary it's a brand new compliance, the advice limitation that's available to implement. Got to convince leadership, drive that top down. What opportunities can you find in actually making these changes and trying to package this regulatory changes coming in with other opportunities that you might have, like client intake. And then finally understanding what your client base looks like do you actually have any data that's likely to be missing that you may need to, backfill or remediate, as they say, later on, so that you are compliant? Because, after you've onboarded the client, you have an obligation to perform the ongoing due diligence, and that is really understanding your client and keep understanding for the whole life of that client.
And you raise a good point, and sort of off script a little question. One of the really interesting things that came up in this panel was, the type of transaction that you're dealing with the client on that first iteration, that could change over time. The first is a conveyance, and then maybe it's a divorce, and then it's a company incorporation, and then.
So, if I may, there's a great example. I think hopefully a lot of people relate to this. You'll have someone who gets, a well-known client gets a little bit sick. They appoint a lawyer as a power of attorney. That client is suddenly changed from an individual to something else. Then they, unfortunately, get very sick and they pass away. Now you've got a deceased estate. It's a different sort of client again. Then it goes into, a trustee format and so forth. And then, executive trustee relationship is different. There's a minimum of at least 3 different client types there, and that's a client fundamentally is the same. But in AUSTRAC terms, there is most definitely 4 clients, 3 to 4 clients.
Great. Geoff, risk assessment is the foundation of a strong compliance program. How do firms ensure they get that first step right?
Yeah, look, when this legislation comes out, you'll be sick to death of the term risk-based approach. It will be rammed down your throats, because that's what it is. It's a risk-based approach. Indeed, yeah. But it can be quite challenging when you start thinking, well, I've dealt with lots of risks and risk assessments, but I've never had to assess the risk of terrorism financing or the laundering of money. And so often when I go into organisations on a fraud perspective, I'll see a risk register and it's got fraud low. And that's the end of it. And you'd hate for AUSTRAC to be coming into your organisation and seeing a risk register that says money laundering low, and that's the end of it. You need to know and understand your business, your own business. Where are you located? What is your customer base? There are different categories that you will need to have an assessment over. So the nature of your clients, who are they? Where do they reside? What sort of business do they do? Where is their source of income? And all that needs to be assessed in the basis of, are they a risk to money laundering or financing of terrorism? What is the nature of the way in which you deliver services? Is it a face-to-face interaction, which lowers the risk potentially somewhat? Or is it online, you never get to see your clients up front? Many conveyancers would never, ever get to see a client when they're undertaking a transaction. That might increase the risk. As I said, geographies, there are higher risk geographies, lower risk geographies in terms of the risk of money laundering and financing of terrorism. But how do you as a practitioner understand that? Where do you go to get that sort of information? AUSTRAC will tell you that it's a risk-based approach. They will give you some very broad guidelines, but if it's similar to what happened back in 2006 when the first piece of legislation came out, they will say, you know your business better than we do, undertake your risk assessment. So, of course, one of those elements will be the risk of not complying. As Gavin mentioned before, it's sometimes tempting to think there's 110,000 entities and therefore I won't need to go too hard at this. But when I was thinking about that, and I thought back to my time as a police detective, if this legislation was in and I picked up a drug dealer and I found a lot of assets and I knew there was AML requirements on businesses that either sold those businesses or set up the companies that own those particular assets, I'd be then investigating how that happened. And I'd be sending a report to AUSTRAC to say, I've arrested this drug dealer, I've charged him, he's got a heap of assets, and this is the solicitor, or this is the accountant that set it up, or this is the conveyancer that onboarded that. Why are you not aware of it? And that could also trigger audits. So it's something you need to treat really, really seriously. It's the basis of everything you do. If you do it right, it can actually be very helpful because it might reduce your compliance burden. It's not possible to expect that you will eliminate the risk, as we all know. It's about managing the risk And it's being able to justify how you've done that in the event that you are called in for an audit, so that you can hand on heart say, we did our best, even if you were manipulated and suffered a money laundering event through one of your clients.
Geoff, this isn't a one-off thing. You don't just assess the risk of a client on the way in. There's a reassessment that needs to happen. Gavin quickly mentioned before, what sort of cadence and how do you decide how often you need to reassess the risk?
Again, it's that ongoing monitoring, understanding what your clients are doing and being alert to an increase or decrease in their risk. And this is where it also comes through training, because you potentially as a business owner, for example, may not be at the front end facing clients. So you need to be able to train your people to be able to identify these risks, report them, escalate, de-escalate as the circumstances progress. It's always very tricky doing ongoing due diligence, particularly if you, for example, might have a client this year and you don't see them for 3 years. It's a bit easier if it's a regular client and you can pick up on a very stark change in their behaviour. Banks obviously struggle with it simply because of the vast population of customers that they've got, being able to monitor how those trends occur. But it's an ongoing process. It's likely that your AML program will need to be reviewed periodically. It's often every couple of years, independently reviewed. So that's a sort of time period you should be thinking about, but it's an ongoing process for the risk assessment.
Thanks, Geoff. Gavin, can you give us some background on how the rollout of Tranche 1 went and what... Yeah, no laughing, come on. And what support we can expect from AUSTRAC.
Yeah, thank you, Don. I'll touch on a couple of things that have been mentioned. I think previously I said that, that there's a likelihood that because of the absence of a Tranche 2, that your businesses may well have laundered funds going through it already. And so we've touched on this idea of ongoing due diligence. So the reason I say this is because, again, going back to Tranche 1 and so on, they did put a grandfather clause in there saying clients over, if they came on board at this stage, you don't have to go back and do your due diligence. We'll just take them as being given. But I think back to, you may not have guessed, I'm a POM at heart, and I'm a bronze god now because I live up in the north. But when I was back in the early days, I arrived here as a backpacker. My career is very, very different. I've run my company now for almost 5 years. We get payments from all over Africa, Central America, everywhere. Not once has the bank, I won't name them, but they're in the papers a lot now, have they ever asked me questions on further due diligence? I find that quite frightening because things have changed considerably. So I do go back to that just issue I touched on earlier. Please look at your client base, and this is going to sort of happen, I think. Reevaluate who your customers are, because there's always the issue around, and this is going back to the answer to the question of Tranche 1. When Tranche 1 got rolled out, we staggered it, and I will know for a fact, I do not think AUSTRAC will do that. We gave 2 years to bring in the whole suite of obligations. So the reporting obligation came in straight away. Then we looked at the KYC, customer due diligence, and the risk-based approach, and putting a program in place. And every 6 months, a new piece of legislation fell. It was seen at the time as being just, well, frankly, I remember sitting at with the CEO, Neil Jensen, at the time, and deputy CEOs, and we were all at the board table going, would we do that again? And the resounding answer was no. So I do not think AUSTRAC will stagger. What they might do, which the New Zealanders have done, is they might stagger in who's captured. So they might say, the first round is going to capture real estate, lawyers, accountants. The second round, capture motor vehicle dealers, high-value goods. They might do that, but I'm absolutely positive that they will say, as of this date, you're in. And then there was an interesting chat, someone said it might be 6 to 10 months for the obligations to settle in. AUSTRAC cannot say that, because again, going back to when the law is actually enacted, you are meant to be compliant as of that date. So they can't publish anything that says, we won't come and look for full compliance as of, if it's enacted on the 1st of July, they're looking for and expecting full compliance on the 2nd of July. But legally, they probably will have the obligation to say, yeah, we could do that if we wanted to. So I don't think they'll stagger it. They might stagger who comes in. So lessons learned were around this whole sort of implementation of round one, of tranche one, was that people also just did nothing. Because they went, oh, well, we've got 2 years, we've got 6 months staggered. And it's human nature, we all do that. We do. I mean, I would love to lose weight. So, and I want to go back to Scotland and impress my mother and go, look how much weight I've lost. I'll leave it to the last month before I leave to go, right, Gavin, give up the booze, give up the carbs. That's my nature, so to speak. And it's human nature to do that, which means if everyone's given time to do it, they will leave it to the last minute. The banks left it to the last minute. The casinos left it to the last minute. They were given 2 years, and then suddenly there was an explosion of activity. People went ahead and started doing what they were meant to have done 18 months earlier. So I would say that that's what AUSTRAC does not want to see happen again. And again, I'll say this word sophisticated. I think you mentioned it earlier. You are what I would call sophisticated entities. You are lawyers and accountants. You've been to university. You're not dealing with the remitters who have English as a second language. They will show no mercy to you for your failure not to comply, because they will put you right up there as much the people are being sophisticated enough to know to bring this in. So I would expect then tranche one being staggered. They're not going to do that, and I would say just get yourselves ready. Does that answer the question?
It does. Everyone feeling comfortable? Alexia, how can we look at this compliance as something that can benefit rather than burden us? Because we're all feeling really excited about it. What's the opportunity here?
I'm currently in the middle of 4 days of cybersecurity audits. So coming here and talking about money laundering is actually my fun part of the day, because for the rest of it, I'm stuck in a very small room with a bunch of IT people and an auditor so that we can get our ISO 27001 compliance, which is obviously very important to us, but it doesn't make the process any less painful. So we spent a lot of time yesterday with the auditor debating a couple of words and whether or not some of these compliance type of regimes do add a lot. And that's compliance done in the wrong way. Because you're talking about something that's not actually improving the risk profile of business, where reducing cyber risk is obviously incredibly valuable and incredibly important. What we do see is with the AML CTF regime done well, it can actually offer a significant amount of opportunities to the business. So we can talk about it in terms of reducing risk. So we see, for example, that better knowing our client through the KYC requirements, that gives us a better understanding of our client's business. We can better provide services to them. The other part of that is that we can better consider whether the client's a really good strategic fit for the firm. Does it align with the type of clients that we're trying to understand and get? Does it fit with our firm's strategy? As has previously been mentioned, we're talking about financial risk. We can better understand the client, better understand and limit credit risk to the firm. We've talked about reputational risks, and in this context, you can talk about it in terms of you've obviously got, you don't want to be breaching the AML law and be front and centre on the of the Daily Telegraph. But there's the other side of that as well, is you can accidentally be tarnished by being involved in a client with a client that's involved in some sort of slightly dodgy things. So this might help us to know our clients in that aspect a little bit better as well. The other parts that we've talked about in terms of business improvement, so this is our opportunity as a firm to basically redo all of our client and matter intake, all of our conflict checking, all of the way we do our information barriers, how we apply security to matters. So there's an incredible amount of opportunity for us to do this, but there is only that opportunity if you're prepared and looking at this early. If you're looking at it with a month or 3 months to go, then those opportunities you'll be putting in a heap of red tape without actually improving the risk profile of your business.
Thanks, Alexia. Ronald, these compliance requirements, they're always evolving. They're very complex. Just being aware of the changes is hard enough. I doubt they're going to have a big party when Tranche 2 is released and it'll be in the papers going, yay, it's finally here. How do we keep up with this pace, understand the change? Where should we be looking for this information?
Just out of curiosity, may I ask in the audience who are lawyers? Oh, very good representation. So look, the majority of change that we're exposed to, and I mean very generally speaking, and from my experience within law firm, is process-based change. So, how best do you actually deliver process change within your firm? And that's very difficult. There are lots of opportunities where you're paper-based and all those sort of things, where can you seek out an electronic solution that can help you? These concepts that keep coming up every now and again, people talk about workflow. All workflow is an automated process that allows you to use a system or technology to get from one point to an outcome of some sort. So these things are available, but the majority of changes are process. When it comes to Tranche 2, it's about what processes do you need to have within your business that will support AML and obviously meet your AML CTF obligations. So that's tricky. And the way we see that is that to try and get some sort of bang for buck out of this, you want to automate where you can. We're going to have a crack, as Alexia mentioned, at a client intake, and we're looking at that whole process end to end. And there's a view that we can put in electronic forms, we can do conflict checking, and a few other things along the way to try and automate that, including what are the questions you need to ask of your client with regards to KYC, know your client, understanding what they're about, and what do you need to meet your AML obligations. So that's really using tech there to help you. But it doesn't matter if you use tech or not, you still need a process that will meet that end to end. Now, once you get them through the door, then you get this ongoing question that keeps coming out over and over and so forth. And this question that, in general terms, people say risk. The reality of this is very simply, my example on this is, if you've got a client, and this is just out of the air, if you've got a client that is based in Australia, and they are selling gems, and they're a cash-based business, the risk from that should be high. Now, if they weren't doing that, and they weren't doing cash-based business or otherwise, you'd say, okay, it's a little bit lower. What if that client then, you find out that they're actually registered and they're operating out of Syria? Now, Syria is listed as a high-risk jurisdiction. Your risk level on that client goes up. So you could say that maybe gem dealing is actually a high-risk industry. So there's that source of funds question that comes in. So all of these things amount to what I'd call properties around that client to understand what that risk profile means. All we're simply saying here, in the simplest of forms, that the risk on that client is simply small, medium, high, low, and medium. And in that, if we phrase it like that, what are the things that make up? You could even put a score on there. Is it the country that they're in? Is it the nature purpose of the industry? Is it the sort of advice they provided? Are they a complex entity, the 17 trust arrangement? That's a question you sort of immediately go, well, hang on a sec, is that complex? Why is it complex? The question that comes out is that you have to ask why. And you need that to form this risk-based view. And if you can create a score at the back of that, then you can simply say, well, hang on, we've got high, medium, and low. And then when it comes to this ongoing view, when you change address and all those other things, you want to review them on a regular basis. And that's the ongoing part. You're reviewing whether or not your status details and so forth are still the same, have they changed? And then you might go up or down in terms of risk. So very simply, you can attribute a score to your client and then on the back of that, do something with it. Run a report or otherwise hold that against the client file. If you're high risk, you might want to review them often. If you've got medium risk, you want to review them less often. If you've got low risk, hardly ever. So in banking, it's a high risk you review every year, medium every 3, and then low risk you're reviewing every sort of 5 years. So that's when you've got to get their client file and work out what it is.
Why you say low risk you do every 5 years? It's going to accumulate. Why every 5 years? It should be more.
So let's just that's know your client, right? In terms of what they do, if they put I'm going to use the term dodgy transaction through your trust account, that should be spotted straight away. If you're engaging with them on a matter, you will find some of that conversation is in relation to something that's been set up that's complicated, or could be for the purpose or affiliated with maybe a money laundering, and you have a suspicion about that, you'd want to do something about that straight away. If it's terrorism related, you've only got like 24 hours to report that. So the due diligence around ongoing, because this is hard to understand when people talk about risk and ongoing due diligence. It's generally around, what is this ongoing due diligence? What does it mean?
It could have been low risk 6 months ago, but now it's medium risk.
So this is why you base your risk around these sort of properties, industry that they're in, a client type. Is that client suspectable? If you had everything as high risk, if you're going on the basis that if you had everything as high risk, you'd be doing due diligence all the time. And the whole purpose of the risk-based view is that you can explicitly go back to the regulator and said, we have categorized this client as high, medium, and low risk because of these reasons, and here's my audit trail to prove that. And if I find an activity that results, hang on, they are in Syria, doesn't mean you can't deal with them. It just means that you might need to collect some other information about what you're doing with them. They call that part enhanced due diligence. So it doesn't take away from the fact that you have active monitoring on the actual matter that you're working with, but in general on the client file, in terms of checking what that ongoing due diligence, actually can be quite simple once you've got a reasonable identification of what that means. So your tech in that respect, in that sort of source actually helps you reporting or otherwise. The other thing I'd say with regards to the question overall is what is impact to your firm, these regulatory changes. You're trying to understand what that means, and you really got to consider that top-down view is important. Do you need someone who's going to perform that ongoing client? Who's going to review that file on a regular basis? Who's going to collect that report? Who's going to relay that? Who's going to be responsible for training? Is there going to be a schedule you need to put in place to train all your people? There's a requirement within there that everyone within the firm has to have some sort of general awareness of AML, CTF, and what it means. If you say one of your fee earners or one of your partners, for instance, is actually right in that position where they can actually maybe circumvent some of these AML, CTF measures, they are, in that purpose, again, on the risk-based regime, they are a high-risk employee, and they may probably need additional training over and above everyone else. So these are all parts of the things that go together to form that implementation. Trying to keep abreast of these things, which the question is about, really. Change continues. It just happens. It's going to come. There's going to be revisions to the AML CTF afterwards. Have you got the right people in place to support that moving forwards? And that goes back to that top-down view from senior leadership. Have you got the right people in there? Can you manage the ongoing changes that are likely to come through? Tech is a good answer in terms of trying to systemize and make that, but without the process and without your sort of governing principles coming down high level, then it's going to be very difficult to actually do.
Thanks, Ronald. So a few key takeaways there. That know your client. Maybe it's not good enough to just photocopy a driver's license and throw it in a filing cabinet anymore. I like the use technology. If we're going to scale, we use technology. That's not lost on us that it's InfoTrack's responsibility to come to the market with technology that enables you to do this. We know that the keeping aware of change, I think there's some technology out there. If a client changes their address or they become a director of a new company, there are alert services. We provide them. They are available where you can get that alert information in so that you can be more proactive in reassessing your clients and the risks. If I was in a firm and I wanted to solve this problem, I would hire these 4 people. But we're not all in large firms. We can't appoint these 4 wonderful people to solve these problems. So what does a small lawyer, conveyancer, accountant, what small things can they do? And I know, Geoff and Gavin, this is your business as well. Feel free to plug your businesses as we go, but what tangible things can we do to start to get ahead of this problem?
My view would be to try and seek free advice to the extent that you can. Have a look at the guidelines that are promulgated by AUSTRAC. Go to your industry representative bodies. They are there to help you. You no doubt pay fees to be members of these organisations. Pump them for information. Make sure that they're giving you the data and the information you need to protect yourselves.
Thanks, Geoff. again, and this is again a answer which I failed to do in the last question, AUSTRAC will do something. I do not want to speak on behalf of AUSTRAC in regards to what they'll do. Back in my day, and I was single exec level 2 for running the whole outreach. I had staff in every state. I flew all over the country. We ran workshops, all free, non-stop, thousands of them. I don't know what they'll do, because I had the budget and I had the staff. I don't know what AUSTRAC will do, but they will certainly do something to provide guidance, public legal interpretations. They like those. And I think as lawyers you'll understand them, because the PLIs, public legal interpretations, are tricky by the sheer nature of them. So there will be guidance, and they may run outreach. I just don't want to say for sure that's what they'll do, but I would think it's highly unlikely that with 110,000 new entities that they will sit back and just expect this to happen. So there will be outreach from AUSTRAC, some sensitization, there'll be guidance and so on. Going back to the question about what you can do in your business, I remember this from Tranche 1 where we had everything from sophisticated to unsophisticated. The expectation is that sophisticated entities will pick up. They will spend the money. So if you've got a reasonable sized organization, there are an awful lot of online tools, some of it very cheap, that will do your risk-based analysis for you. You can plug in your clients, jurisdictions, face-to-face, offline, online. So there are a lot of solutions out there. However, if you are a small, 1, 2, 3, a small, medium enterprise business, and the burden of compliance is heavy, and the government is extraordinarily aware of the disproportionate amount of burden on a small business. And I would personally say that don't over-engineer it. I saw this in the first round. People all went hell for leather. Finally, when they got around to it, they went hell for leather. I said, don't. You're not that large an entity. You don't have that large a number of clients, and you don't deal in jurisdictions that I would say were high risk, and you're not high cash, you're not this. So I would look at it and say, do an initial look at it and say, what clients, what vulnerabilities have I got? Who have we got historically? Where do we operate? If I'm selling houses in the eastern suburb to Russians, should I be worried? Of course you bloody should. So, I would be looking at things and saying, what does my business run and what have we got? But don't over-engineer. If you're small and medium, you've got plenty of space. Don't have to go crazy. It's just that AUSTRAC will expect you to have something written down. If you find your clients all low risk, justify it. And if you can justify it, AUSTRAC will say, thank you very much, that works for us. They just don't want you to do nothing, which is part of the last question. My advice is do something, not nothing. Just don't, this is not going to go away. You're going to have to do something. So I would look at free advice, whatever you can get your hands on that's out in the public domain. AUSTRAC will certainly help you. And as again, I think the larger and more sophisticated you are, the expectation's higher. And I think that's fairly reasonable to expect. If you're a smaller business, there's not a huge expectation there. It's just that you've done something, that all staff know about it. You keep talking about the board level. The anti-money laundering officer, the AMLO, that's the toughest gig, I reckon, because I wouldn't want it. But the laws are very clear on this. It's the board level. So if anyone's going to go to jail, it should be the board, because the board sign off. But everybody thinks that they can just kick the AMLO officer under the bus. I don't think that's going to be the case. I think they're going to look at board level and say, how did this go through? Hence the reason of the CBA recently. The CEO left because ultimate responsibility sat at that level. And I was, unfortunately, on the ABC radio and said heads will roll. So I'm surprised I'm still got to count with the CBA. But what I would say is that please do something, and I said take it very seriously at the top level. Document everything, write it down, and show your due process of why we've done this. That's my advice.
Great. We're at 1:30 now. The panellists will be staying behind for a bit to take questions after this. I might wrap up at this stage so we don't go too far over time. I'll conclude by saying, and I think we made some good points, is that you need a compliance program, and you can start doing that now. You don't need to wait. Get ahead of it. It's important you start thinking about the implications of Tranche 2 now. You'll need the right tools and technology in place to ensure that you have a consistent, reliable and adaptable process that grows with your business. Let's not overbake it. Put something in place that is fit for your business. We've created an ebook that came out of the back of this discussion that we will send out to everybody that's come today, and we will endeavour to provide you more tech, as Ronald mentioned, to help you navigate this change over the coming year. I'd like to thank very much the panellists. Thank you. And thank you everyone. Feel free to stay around and ask questions.